Hello, everyone. Thanks for being here. We're just gonna wait maybe a minute or two before we get started, but we appreciate your being here. Hello, everyone. We are right at that 12 o'clock, 3 o'clock mark. We're gonna get started in just a moment and let folks have a chance to end their meetings and pop over. We'll be starting soon. Hey, everyone, we are going to get started. First, I want to start off by saying Happy Lesbian Visibility Week. I hope you're all celebrating responsibly. My name's Imani Rupert-Gordon, and I'm the President and Executive Director for the National Center for LGBTQ Rights. And I want to welcome you to another NCLR briefing. I know there are some new faces in the room, so if you're unfamiliar with us, we are a legal organization and we work to achieve and advance civil and human rights for all LGBTQ people and their families. And we do this through litigation, legislation, public policy, and public education. Today, as part of this training and as a nod to Lesbian Visibility Week, we're going to be talking about LGBTQ family law. Today, we're going to share with you some of the history of family law, specifically when and why NCLR started doing this work decades ago, and what we're seeing right now and what the landscape looks like in this moment. So we know that there's a lot going on, and what we're seeing in the South, we can expect to see in the rest of the country. So we're going to spend a lot of time there today. We're also going to highlight some bills to pay attention to and talk about an active case that NCLR is working on right now. So as many of you know, NCLR's family law program was specifically created to protect lesbians and LGBTQ women from losing their kids when they started building their lives with women. Now, of course, that work has gone on to protect countless families of all genders, races, ethnicities, LGBTQ and not, because when you work to create inclusive policies, all families are better and safer for it. So as a quick housekeeping note before we start, there is a Q&A function. If you have a question, please feel free to put that in, and the panelists will either answer it in real time or type the answers in the chat. So you can use that throughout the webinar as people are speaking. And then if you have any more in-depth questions or something that's a bit more personal, you can feel free to email us and we will let you know how to get in touch with us at the end. So yeah, that's what we have for you. Before we get started, well, I'm just gonna introduce our amazing panelists today. So we are joined by the incredible Amy Whelan, who is a senior staff attorney here at NCLR. And we have two esteemed guests joining us today. The first is Kris Williams, the plaintiff in Wilson versus Williams, one of NCLR's family law cases. In just a little bit, she's going to share a little bit more about her case. And so you'll get to find out more about that. And then finally, we are joined by Milan Pham, partner at Nichols and Pham and longtime NCLR National Family Law Advisory Council member. So, Milan, we're going to start with you. Why don't you get us started and tell us about what's happening right now related to family law and what we're doing about it?
Thanks, Imani. And thanks to NCLR always for ensuring that our community has timely and accurate legal information. Particularly, thank you for allowing me to turn an eye to the South in this moment when Southern queer families are so challenged. Recognizing our region as a political and cultural bellwether and driver of national politics and social movements, W.E.B. Du Bois once said, as goes the South, so goes the nation. And we are really seeing that now. The Movement Advancement Project estimates that 36% of the country's LGBT population resides here. The largest regional concentration of queer people in the United States, and 4 out of 10 of those queer people are also people of color. So we have intersecting and overlapping oppressions happening. North Carolina is both a battleground and a barometer on LGBT issues in our region. It's also the gateway to the South in terms of policy. We lead the nation, unfortunately, in gerrymandering and the consolidation of extreme partisan power across all arms of government, and it's been serving as a blueprint for what we're seeing happening at the national level. We do serve as an abortion sanctuary for our region and remain a place where queer and trans families can find protection. If we can, under these circumstances, gain ground here, we can gain it anywhere. And so the road to a more just future is running directly through the South. Queer family protections vary largely from state to state. NCLR knows this, as does our community, with family protections being more robust in some states than in others, and the most challenging family protection environment probably here regionally in the southern United States. I'm going to focus a little bit on North Carolina because that's where I'm licensed and that's what I know the most about. But North Carolina is emblematic of what we see across the South. North Carolina does not have the UPA, the Uniform Parentage Act, for people who are not attorneys on the webinar. Like most southern states, we haven't enacted any version of the Uniform Parentage Act, which covers families created through ART and surrogacy. That doesn't mean that we're not creating families through ART and surrogacy. It just means that we don't have easy ways to protect those families. And while various versions have been proposed, they've never made it out of committee, and for reasons that I'll discuss later, we're unlikely to bring the UPA forward to the General Assembly now. Marriage is recognized since Obergefell in North Carolina, and there are no current challenges to marriage originating out of North Carolina. Following Obergefell, the General Assembly passed a technical corrections statute correcting gendered identification of spouses, husband, wife, widow, widower, and largely people have been complying. We haven't heard anything on the ground about people not treating same-sex married couples as they would different-sex married couples, not currently. The door to parentage opened up after Obergefell. Married people in North Carolina are presumed to both be parents of their children for any child that is born during a marriage. Importantly for our community, that presumption is rebuttable. And what that means is that it can be disproven, rebutted by evidence that a child is not genetically related or that a child has not been adopted or an order hasn't been entered. Clerks are granting step-parent adoptions and judges are granting confirmatory declarations of parentage. And so we do have an environment where our families are protected in North Carolina. We've got an ART statute that does not cover donor eggs, donor embryos, or surrogacy for same-sex or different-sex couples. And because technology is advancing rapidly, the law is having a hard time keeping up. And North Carolina's ART statute only addresses donor insemination. And because our families are different, the statute doesn't cover us in many ways. After the technical corrections bill, we're assuming that the ART statute that says two married people who agree in writing to the use of donor sperm are both parents, we assume that that applies also to us lesbians who give birth during marriage. But there hasn't been an appellate case that shows that that's true, at least not a published one. We did have an unpublished appellate case in 2022 where two lesbians had a known donor. And ultimately, in that case, I think the court found that the non-birth mother was also a parent, but also declined to dismiss a paternity lawsuit by the known donor. And so it was sent back to the district court and it has not had any further action. We think it was unpublished because it's the first time the North Carolina Court of Appeals is recognizing more than two parents. We've heard that there's a case pending in a Western county in North Carolina wherein a birth mother is challenging the application of the presumption of parentage to her same-sex spouse, and we don't know where that's gone. So it's still pending in the courts at this time. Because the laws weren't written for us, they've not considered the ways in which our families need protection. And advice from attorneys unfamiliar with the gaps leave our families really vulnerable. Solutions for our community continue to require a lot of creativity and a willingness from the judiciary to protect families in ways the judiciary is maybe not used to protecting families. The best advice remains that parentage should be confirmed by step-parent adoption and order declaring parentage, that all of our families should have financial and healthcare powers of attorneys and wills or trusts providing for our families. In North Carolina, like across the country, trans people are being targeted. While gender marker changes are permitted in North Carolina, our current governor, who was the Attorney General a few years ago, implemented a streamlined strategy for gender marker change that remains viable. And because of Campus versus Cohen in 2022, trans people in North Carolina are no longer required to undergo sex reassignment surgery in order to have gender markers aligned on their birth record. North Carolina does have a ban on gender affirming care for minors, and I've recently received news of a transgender minor being refused necessary medical care unrelated to gender affirmation because of their trans identity. And so these are some of the things that we're seeing on the ground as legal advocates. And our work for family protection is happening in a much larger legislative, political, and cultural background in the state and across the nation. You know, Imani, that North Carolina is the home of the original bathroom bill. And early on, we began fighting the exclusion of trans people from public places. We've since then had a Parents' Bill of Rights in 2023 that restricts discussion of sexuality and gender identity amongst educators and students, forces school faculty to out children to their parents. We've had a ban on gender affirming care for minors under the age of 18 unless they were grandfathered in for some reason. And in 2025, we had House Bill 805, named the Prevent Sexual Exploitation of Women and Minors Act, that codified a binary definition of sex. It increased the time to bring malpractice lawsuits against gender affirming care providers in an effort to dissuade them from providing care for adult trans people. It creates a permanent record of changes to North Carolina birth certificates, meaning that it is outing trans people almost exclusively. Bans gender affirming care for incarcerated people and requires students to be housed according to sex assigned at birth on overnight field trips, creating danger for trans students. In 2025, the Parents Protection Act was passed, and it basically leveraged child welfare laws in an effort to lay the groundwork for future claims that parents providing gender affirming care for their children are abusing their children. This law says that it explicitly excludes from the definition of abuse raising a child in accordance with their sex, which of course makes the contrapositive true, that if you raise a child in accordance with their gender identity, that you might be guilty of child abuse. And we passed the Criminal Illegal Alien Enforcement Act, which requires North Carolina local jail administrators to determine citizenship status of inmates and report to ICE. And this is largely because localities were refusing to cooperate with ICE. And shortly after the passage of that bill, a local trans Latina leader who's lived in North Carolina for 30 years was detained and sent to Stewart, Georgia, where she's being housed in a men's facility. So we are looking at a legislative atmosphere that is hostile to our community. The Greater Than campaign, which you know, Imani, is a campaign expressly seeking to reverse marriage equality using the false rhetoric that children of same-sex parents are subjected to being treated as less than the children of different sex parents. One of their primary organizations is located in North Carolina, the North Carolina Values Coalition. And North Carolina Values Coalition had a hand in now the Republican control of the Supreme Court, as well as the North Carolina General Assembly. So we do expect challenges to marriage equality to be coming through North Carolina in the future. The North Carolina Supreme Court, working in conjunction with the General Assembly, is amassing partisan power and deploying that power against its political opponents. North Carolina lawyers, this is important for this community, are self-governing, and our discipline is administered by elected peers under the purview of the staff of the State Bar. Recently, the General Assembly convened a task force to review the grievance committee of the State Bar. They requested voter registration records of every grievance committee member, and they requested that the State Bar provide records of any political donations that those grievance committee members made. While the State Bar denied those requests because the State Bar didn't have that information, it's likely to be a battle moving forward. The General Assembly is seeking to have all grievance committee members be political appointees, appointed by either the General Assembly or the Chief Justice of the North Carolina Supreme Court, or the governor. And we fully expect that if that happens, there will be targeted disciplinary actions against attorneys whose work doesn't align with the General Assembly's views. And so these changes in our atmosphere have impacted our ability to protect the community. Flooding the field is having a distinctive impact on us. Community members are exploiting known legal gaps. I've always said that the greatest protections for our community originate within it, and that we, above all others, should use the law as a shield and not as a sword, but that is not what's happening. And so in the coming years, I expect to see more cases brought by our community against our community. Legal allies have become reluctant to use their authority on behalf of our community. Judges and clerks willing to exercise discretion on behalf of our community are becoming reluctant both to do what they once did and are increasingly unwilling to help us advance any ground. They're anxious about protecting families created by ART, and it's impacting our community significantly. Additionally, we're seeing a lot of compliance in advance. Even in our most progressive areas, we're seeing compliance in advance with executive orders, which are not law. UNC Hospital ended gender-affirming care for people under the age of 19, which is more restrictive than what North Carolina law requires. And they did that based on an executive order that was issued and out of fear of losing federal funding. As attorneys for our community in this moment, we're required to know more than just the laws of our state. And we're required to know more across many practice areas. As queer family mobility becomes a part of safety planning, we're increasingly connecting families to resources outside of our geographic areas and sometimes outside of our state. But lest you think that we are without hope, we are also flooding the field in our own way. We're creating coalitions worthy of the world that we're building, focusing on culture, legislation, and the judiciary. We're leading intersectional, interracial, intergenerational, and cross-class movements in North Carolina. The queer community through Equality NC is leading the America Votes Table, Progressive Coordination Hub. We primaried and unseated the 3 Democrats who sided with Republicans to overturn our governor's vetoes that would have protected the LGBT community, and we replaced them with much stronger progressive candidates. The Senate leader, Phil Berger, who is the architect of the worst anti-LGBT legislation in the state, was unseated in his primary this year. And we've been electing queer and trans people at every level of government in localities across the state. The Progressive Coalition has created and is implementing a 2030, or at this point, maybe even a 2028 plan to take back the Supreme Court of the state and the General Assembly. We're resurrecting old tools and getting back to the work of building our own infrastructure. We haven't had expansive rights for all that long. You're talking about the history of NCLR, which Amy's going to get into in just a second. But it wasn't that long ago that we were shoring up our family structures with duct tape, contract law, community fidelity, and sheer will. Like, that is what we had. We did not have the law on our side. Today, we're in a very different position because of NCLR's work, the National Family Law Advisory Council, and the National LGBTQ Bar. We're networked across the country, and we're building communities of care everywhere we land and in every state. And for the first time in a decade, in February, the Southeast Regional Family Law Institute of the National LGBT Bar convened in North Carolina, and NCLR continues to be a leader in the work of protecting our families. And so that's yours, Amy.
Thank you so much, Milan, and thank you for giving such a great summary of things happening in North Carolina and the South, which is so important for all of us to be aware of and know what's happening. Like you said, Milan, protecting our families has been a very core part of NCLR's work since we were founded in the late 1970s. And in fact, it was one of the reasons we started. When Donna Hitchens and Roberta Achtenberg co-founded NCLR, like Milan mentioned and Imani, lesbians were losing custody of children from former relationships. And their ex-husbands were arguing to courts that those women were no longer fit to be parents only because they were now dating women. And Donna and Roberta understood the serious harm that children and families would experience if judges agreed with that. And so since that time, we have been fighting for our families. Even back in the early 1980s, we successfully represented Sharon Johnson to gain legal custody of her son, and NCLR then published an old manual, which I wish I had a copy of, called the Lesbian Mother Litigation Manual, to guide lawyers around the country who were representing gay moms in their custody battles. And really the goal of our work is pretty simple, and I think, stands the test of time. And that is that we want to make sure that LGBTQ parents and their children are fully recognized as families under the law and in society. And we also understand we can't be everywhere. And so we need attorneys like Milan working with us and partnering with us for the last 30 years through our National Family Law Advisory Council, which now includes multiple lawyers all across the country. And that's essential, like Milan mentioned, to make sure that we aren't just all isolated. We're not just living in bubbles, that lawyers around the country can share strategies and lessons learned from cases that we experience. And, whoever the first people who are going to be who deal with those issues, it's essential for them to share that information and experience, and that's the purpose of that network of lawyers. Some other highlights of our work include, of course, we do litigation and advocacy to protect non-biological parents from losing custody of their children or not being recognized as full parents. Milan talked about some of this. We're lucky enough to have Kris on here today, too, who will talk about her experiences with this. We've litigated several of these cases over the years. One example is a case in 2005 where we won a ruling from the California Supreme Court that when a couple deliberately chooses and plans to have a child through assisted reproduction with an anonymous donor and then jointly parents the child, both parents are legal parents, regardless of their gender or their marital status. And this was a very important ruling that paved the way for other protections for LGBTQ parents as well. And of course, we worked for many years on marriage equality. NCLR was lead counsel for same-sex couples in the landmark California marriage equality case in 2008. And throughout the rest of the 2000s, we also litigated marriage cases around the country in multiple states and achieved some of the earliest wins in states like Utah, Idaho, Alabama, North Dakota, Florida, and our Tennessee case, which was one of the consolidated cases that established marriage equality nationwide at the U.S. Supreme Court. And I just want to say I personally benefited from this work when I married my wife in 2005. Like many of our friends, I honestly did not think much about marriage as a younger person. But I have seen both professionally and personally the incredible effect it has had on people's lives as they age or as they decide to have children. There are complex and very expensive ways to try to get those same legal protections for us and our children without a legal marriage, but those are simply out of reach for a lot of people in this country. Our work also focuses on access to assistive reproductive health care and protecting the children who are part of those families. We do this through legislative advocacy and impact litigation. And the goal is to make sure parents using assisted reproduction and surrogacy are recognized as families, and that the rights of people acting as surrogates and egg donors are fully protected. And, Milan talked about the Uniform Parentage Act, which states like California have passed and North Carolina sadly have not, of course. NCLR supports that law. And because of the reasons Milan identified, it updates issues around assisted reproduction and same-sex parents, which many older state laws just simply don't address or address in a bad way that should not be part of current law in this country. So I'm going to be quiet soon, but I want to just quickly mention a couple of other NCLR cases that touch on these family law issues. One is that we represented Mary Walsh and Bev Nance a few years ago in a case against a senior living facility that they applied to live in. Mary and Bev were both retired, and they were looking to move into a place that could provide, accelerated and different levels of care for them as they aged. But when the facility learned, after months of wooing them, that they were married and not sisters, as the facility originally falsely assumed, the director told Mary and Bev that they couldn't live there and that only opposite sex married couples were allowed. So we litigated a sex discrimination case for them to make sure that their family was recognized, and eventually were able to settle that case to resolve it. In another case, we represented Lee Taylor, a 74-year-old Navy veteran who tried to make arrangements for her and her wife's ashes to be interred at the Idaho State Veterans Cemetery, as other veterans and their spouses were allowed to do. The cemetery refused because they were a same-sex couple. So we represented Lee, and we won a decision that the cemetery's policy was unconstitutional. At the same time, we were litigating the Idaho marriage equality case, and after we won that, we had both wins in that state. And sadly, Lee died a few years after those decisions, but she was interred with her wife exactly where she wanted to be. We've also represented clients like Jennifer Tobitz, who needed legal help when her spouse, Ellen, died very young of cancer. That illness really took their family by surprise. And sadly, Ellen's parents, who never supported their relationship or their marriage, tried to block Jennifer's access to the spousal death benefit that Ellen had through her employer. We fought for Jennifer in 2 states, in Illinois, where the couple lived, and in Pennsylvania, where Ellen's old company filed a case to determine whether Jennifer or Ellen's parents should get the money. And with the help of local law firms and the law firm Kirkland and Ellis, we made sure Jennifer was recognized as Ellen's spouse and that she received that benefit as she should under the law. So, these cases really show that different issues come up for our families at different stages in life. There are custody and childcare issues for younger parents, medical crises and estate and life planning issues maybe a little later on, and then the need to protect our children and our families as we get older and even after death. So, these issues span the lifetime, and we need to make sure that the law always respects and recognizes our families throughout that lifespan. So With that overview and some of the highlights of our work, I'm going to turn it over to Kris now, one of NCLR's amazing clients, so that Kris can also tell her story. Just a warning, her case is a stark reminder that even when we make incredible legal progress, we have to stay vigilant as a community. And like Milan said, that requires all of us to protect our wins and to make sure our families have all the rights that we deserve. But thank you, Kris, for being here today.
Thank you, Amy. I will tell you, and I told them before we got started that I was pretty nervous about getting on here and talking, and I'm a public speaker and typically not nervous about stuff like this. But over the last 30 minutes, hearing my sister speak, I will tell you that you have empowered me to believe that I am not alone. And that is probably one of the biggest things that somebody like me going through this needs. And so I just wanted to start off by thanking y'all for that. There is a phrase that I just want to, my former spouse and I had a child together with what's called in the law marital presumption, meaning that the law assumes that when a married couple has a child, they are the child's legal parent. So I just want to say, in the state of Oklahoma, after the child turns 2 years old, nobody can come back and contest that child if you're legally married. And so there is a little slippery slope within those 2 years. So I just wanted to kind of start off with that little landscape. And so where I want to start with my story is that me and my ex met in 2014, started dating that summer, and 4 years later we started talking about having a baby. She said to me at the very beginning that she never wanted to have a child, but after witnessing me as a mother to my child from my previous marriage, my first marriage, my child was from adoption from the state. Got him when he was 5 years old. He's 19 now. And so she just said, I love the way that you parent and I want to have a family with you. And so I was down with that. We started speaking to some friends about how they went about things because I'd gone through this before in my previous marriage and know that insemination is extremely expensive. And we both worked in the nonprofit sector. So it wasn't like we were just rolling in dough. And so we had talked to several local lesbians and how they had proceeded in having their families. And one particular couple had mentioned several websites. One of them that they used was called Have a Baby or Just a Baby. And they didn't want any contact with their donor, but due to my oldest child being from adoption, I want that connection to biology. If my child ever wants that connection, I want to be able to offer that to them. So we started searching for a donor that not only looked like me and had traits like me or talents like me or whatever, but it was also about, finding somebody that could potentially be a part of our lives, maybe a guncle. And that was what was very attractive about this Just a Baby website, is that there was a lot of gay men on there that were offering their services. And so during that summer, as we're looking at things, we decide on somebody and we start talking to him. And he lived in Dallas and we're in Oklahoma City. And we soon, were really getting along with the guy. And my ex was on the PFLAG Council at the time, Oklahoma City chapter, and they had a conference in Dallas. And so she said, "What do you think about me meeting him with my board from Oklahoma City, PFLAG, and having him sign a donor contract? Even though there's not really any legal weight, there's intent, and so we can at least show that." And I said, "Absolutely." And I couldn't make the trip, but they took pictures, they called me, they memorialized it all. And so what happened after that, and this was about the fall, it was Halloween when we signed the contract. The first week of December that year was 2018. We invited him to our home in Oklahoma City and we proceeded to inseminate for 3 days straight. He was very nice and would hand me the specimen and I would inseminate. And then 2 days before Christmas, after we had sent him back home to Dallas, 2 days before Christmas, we get a positive on our pregnancy test, and we're very excited. Did not expect to get pregnant that fast because we were also planning on getting married and hoping that it would go married and then pregnant and then baby, but it didn't. It went pregnant, and then that next February of 2019, she got a bunch of our family and friends together and asked me to marry her. And so we got engaged in February. We had already had our first ultrasound. We're still talking to the donor. We had invited him to come down for the ultrasound, the next one, and he did. And to make a long story short, he did something that made her nervous, and she's also pregnant and very moody, right? A lot of hormones. And so she just wanted him out of our life right now. And so I drove him to the Oklahoma City airport, and he was gone. We proceeded to get married on June 1st of that year of 2019, and our baby came on August 19th of that year. I asked her if I could send a picture to the donor saying thank you, and she allowed me to do that. And he said, "Congratulations, what a beautiful baby." And on our baby's, mind you, we're still no contact on our baby's first birthday, she said, "I think we need to get in contact with the donor." And I was, again, all about that because I want connection to biology if we can make that happen for our children. And so we started speaking to him in, I got to check my notes. Started speaking to him in August of 2020 after Warren had turned 1. And it was that next Easter, the April of 2021, that we had invited him and his family down to have an Easter with us and to meet our child. And that happened. And then the summer, a few months later, he decided to buy a home in Oklahoma City, and he did. And then by Halloween of that year of 2021, my marriage had declined. And on November 23rd, I went to go pick up my child from school, and he was gone. And that was the last day I saw him. He was 2 years and 2 months old, so we were past the 2-year mark. So I felt confident as long as I had that piece of paper of him signing over his rights, but I didn't have it, and she wasn't willing to give it to me. She filed for divorce on December 1st, or got a lawyer on December 1st. And so I proceeded to get a lawyer myself using a friend of mine who essentially sent me to her mentor, another lawyer. And I say that because on around December 18th, I get a call from my lawyer friend, and she said, "I want to make for sure that you're sitting down right now because I got to tell you something that's going to really hurt." And she said, "Your ex has claimed that there was no child of the marriage. After I was already put on the birth certificate, I cut the cord. Everything was dandy, if you will. And I knew right then and there that she was going to use the UPA against me." Now, one thing that I haven't talked about is that I've done a lot of queer trainings in the past, worked with youth groups, and my ex was also doing that work with me. And we'd done a lot of trainings for the state of Oklahoma on our family issues and the protections, the lack of protections when it comes to family law, and how there were things that, like the UPA in Oklahoma, that says mother and father instead of parent and parent, could be used against us and weaponized against us. And she went ahead and did exactly that. And so my lawyer, my first lawyer, was a straight woman who I didn't think she was going to get it, and she didn't. She said, "You're absolutely protected, Kris. You're legally married. The child was born during the marriage. It doesn't matter." And we went into court, and I was pummeled. And so one of the things that I was talking about is that, I live in Oklahoma. I look like this. I am very aware of the discrimination that goes on around me, but I walk in this world with blinders on purposely, because if I see all the hate around me, I am just not going to be able to thrive. I'm going to be able to just barely survive. And so walking into a courtroom, you can't have blinders on. But let me tell you, my white privilege was very astonished that the law didn't protect me. When I walked in, and my ex, who has passing privilege, and the donor, who has passing privilege, sitting there looking like a straight couple, I looked like a gay pride parade walking into this courtroom, and was very aware of how the judge was perceiving me, and just her mannerisms, her body language. And ultimately, what the judge said to me in this whole ordeal was, because she was considering things until they really hammered that UPA. And she said, "Christina Williams, because you were born a woman and you identify as a woman, you cannot be a father." I never wished to really be trans until that moment. I was just like, what would you have done if I was a trans man? I just couldn't believe that she had used that language against me, and she did. And so, there's I don't know where else I want to go with this. There was this back and forth at the very beginning. I did get another lawyer. I immediately, because of my connections in the community and the work that I've done, started calling colleagues out in California and New York and wherever I could, and eventually got a hold of Shannon. And he was my saving grace because I knew Oklahoma was about to eat me up. And so right now we're at the Oklahoma Supreme Court. We're waiting on them to make a decision. It's been on their desk for a little over a year. They don't have a timeline, from what I understand, on when they have to decide. So we are just we're just sitting in waiting. And so there was only one other point that I wanted to make that was written down, and I just like this to sum things up, is that it's particularly frustrating because the Supreme Court has already said that it does. Pavin versus Smith said that because of the marriage equality decision in Oberfeld versus Hodges, that marital presumption, of parentage should be applied equally. And obviously that didn't happen in my state. And so it's my understanding that there's other states that still have these mother and fathers written into the UPA, and other families are in this kind of danger. So, I've never thought in a million years I would be in this position, or I would have adopted my son those first 2 years, but I chose to trust my spouse that I did trainings with in talking about this specifically. The audacity of when you do advocacy and you look like this, and I think a lot of us can relate to this, when you fit outside the norm, whether it be race, gender expression, whatever, is that we are the ones a lot of times on the front lines really making sure that people are getting their rights. And so when the ones that are passing weaponize these things against us, that is a sword that nobody else can really put upon you. I just don't know I don't know how to describe it. It's who do you trust if you can't trust your own, you know? And so I appreciate NCLR. I appreciate Shannon. I appreciate my sisters here today and speaking about this, because, not only am I doing this for my family, but as an advocate, as long as I have been, I'm not the first one this has happened to, but I'd like to be the last.
Kris, thank you. Thank you so much. Thank you for your strength, for your bravery, for your advocacy. We are so, so grateful for you.
You're welcome. Thank you.
Thank you. Thank you so much for the heart I see in the chat. Really appreciate you all. In just a moment, I'm gonna open up to see if there's any Q&A. So please, feel free if you have any questions, please add them. If you have very specific questions, that should be public, please, go ahead and email this to us. I'll share that information at the end. But before we do, Milan, do you want to, just have some closing remarks?
Sure. I think Chris's story, thank you so much, Kris, for sharing that. It is both the gift and the burden of being queer that we are in this space. And it is hard to be an advocate and to be a targeted person. And I heard you. I heard you when you said that, Kris. Queer people, by definition, we evolve and innovate every system we enter. As outsiders to a system built on oppression, ownership, and control, that is always going to be true. Our family formations as they are today are not going to be what our family formations are moving into the future. Because we exist everywhere, we're leading the movement for self-determination, bodily autonomy across every race, every nationality, every religion, every creed, and every industry, and across every institution. I mean, we're uniquely qualified for this moment, and we're uniquely burdened in this moment. Our relationships, they're breaking the box of patriarchy, which is why we are getting so much pushback. Until we're all free, it's likely that our community will continue to lead the way into deconstructing family and identity systems built on ownership and control. That doesn't mean that we're not paying a great price for that. We're not satisfied to enter oppressive systems and remain oppressed. And so we're transforming the institution of marriage. We're enlarging the definition of family. We're exploding in the very best way the concept of love. And we're building through being, just being ourselves, a world that we have never seen. And we're laying a path of freedom on which everyone else is walking. And that takes strength, determination, creativity, and moxie. And unfortunately, visibility is inviting attack. And it's taking a toll. And you're seeing that toll right now on this panel. There's not a person here who does not go home and wonder for their own safety. You know, there isn't an attorney who is fighting for our cause who doesn't, in their remarks, say, these are the arguments I'm making for the community, and then makes a note to themselves, don't cry. Make this argument, don't cry. Make this argument, don't cry. That's the reality of where we are. And that's why we need NCLR more than we've ever needed NCLR before. Organization first formed to protect our families when nobody considered us to be family, and currently handling the most groundbreaking litigation for our community. You're intersectional before it was cool, and you're intergenerational by design. And that's why we need you. And that's why we need us. Like, we need to be better as a community. We need to come together across all of our differences. And that's how we build a world that is different than the world that we're living in.
Thank you so much for those beautiful remarks. Really appreciate you so, so much. I want to open up. If there are questions, please go ahead and send them. I see this isn't a question, but wants to send support. Michael, thank you. I too had an ex-wife, same-sex marriage prior to my transition, shut me out of my child's life and used the court system to help her. Thank you for the hard work. Thank you so much. We know that discrimination happens all through, even within our community. And many people don't think about that, but that absolutely happens within our community, that folks in our community are able to weaponize and use discrimination to continue to hurt us. Kris, there's also another question for you. This is really painful, so I actually I'm going to broaden this a little bit, and please just answer to the low of your comfort. But if you could speak about how has this process been like for you? This has been a very long process. We've been waiting for this decision for over a year. What is it like for you waiting for this? Do you have any contact with your son? How are things going there, and how are you managing?
Yeah, no, and thank you for the question. I haven't seen my son since that November 23rd of 2021. Um, I work in our community. And so, and raising kids in our community, and it's a burden to be a mentor, but I mean, it's like being a parent. You can't expect your children to make it through this life without showing them by example how you can make it through this life. And so it's just literally one day at a time, and surrounding myself by people that love me and people that I trust. It's hard.
We're so grateful for you.
Thank you.
Any other questions before we sign off? Okay, Liz, thank you so much. This was so great. Thank you all. Such a reminder of the importance of confirmatory adoptions. Does NCLR have any resources for protecting parents of trans kids specifically, as some are getting some gender-affirming care for kids, and are worried about being targeted, doxxed, or exposed online? Amy, can you answer that?
Yeah, thank you. And that question was from one of our NAFLAC people. So hi, Elizabeth.
Mhm.
So happy to have you here, and I saw some other folks on here too. We do have resources, and people should check out our website. And also, if you have any specific questions, we have an amazing attorney, Ming Wong, who handles our helpline. And you can reach out to Ming, and he will get all relevant questions to the right people at NCLR. And then we will network with whoever we need to get folks help and advice. We've put together lots of FAQs and fact sheets. Some of those we put on our website, and you can just find them. And some of them we can provide to you if you need them. Um, and, it's interesting that people are talking about trans parents losing their custody. It does feel like a time, and it has over the last few years, where trans parents are facing the same, sadly, years long struggle of lesbian parents and same-sex parents like Kris over the years who get, they basically face these issues where there are arguments made about them in the context of custody proceedings that have nothing to do with anything that relates to their actual ability to be a loving, supportive, kind, and parent who allows their child to thrive, but is simply like a lodged allegation that because of our status as a gay person or a transgender person, we are not a fit parent. And I do want to highlight the extreme danger of that framing of things in legal courtrooms. I mean, it's truly, truly horrifying, and it seeks to blow up families and, really harm children who need the support of their loving parents.
Yeah, can I piggyback and just say with the whole adoption thing is I don't think we should have to adopt our children. Why should I have to pay $3,000 because I'm a lesbian? When we're doing, insemination and filing paper, it's just it's another roadblock that they put in for us. That, I mean, what's ridiculous is that I've got a kid who's a therapist that one of her patients died after having a child 8 years ago to a man that she wasn't legally married to. The legally married guy was in Las Vegas. He had to come and sign over his right to this 8-year-old child because they were legally married, even though he wasn't the biological child or biological father. Does that make sense? I feel like I ran all over the place with that. But anyways, the whole point is that because they were legally married, that child was of that marriage, even though he was not um, the sperm donor.
Yeah. Kris, it's really, I think what you said is really important, and it really strikes a chord with people. But, as lawyers, and because of the patchwork of different state laws that happen around the country, and because we don't know what parents are going to face, we always do advise people to take those extra legal steps if there's any way they can. And, if money is a barrier or something else, there might be ways to help that, but it is really important, especially in this moment, that people take all the steps they possibly can to protect their families and to do those second parent adoptions or take other actions that add just like another layer of legal protection for our families. And so anyone who calls our helpline and they ask and they have those same concerns and they think it's unfair and they live in a state like New York or Massachusetts where they think they'll be okay, you still should be careful because you travel to other states, you might move to another state, you never know what is going to happen. And so, I hope people will reach out to the amazing family law attorneys that are in their communities and also to NCLR and to other groups whenever they want just a sounding board for those things and to understand what is it that they should be doing to protect their families.
No, thank you, Amy, because that's not my intention
Oh, yeah, yeah, no, but you're
but yeah,
exactly
it
right.
sucks. But yeah,
Yeah.
Exactly right. It's so unfair that that has to happen. And it's incredibly expensive, like you said, incredibly expensive. So,
Thank you so much. So we have some more people sending support, sending thanks, sending strength to you, Kris. Thank you for being advocates. Someone's asking, we support NCLR, but if there are other ways we can provide support, it's easier for our family in New York. One of the things that you can do is share this briefing with folks. You know, something that is certainly a problem is that many folks believe that this isn't happening in our community or happening anymore, and it actively is. And so, if this has changed the way that you are able to explain, if you want to have a conversation with someone and you want to reach out to us, let us know. We can talk to you about this in plain speak so it makes a little bit more sense. But we want this to, in this age of misinformation and disinformation, it's really important to know what is happening to our community. I think that's something really important. Someone's asking, clearly, this administration is interested in targeting our community. Do you think the Supreme Court will reverse their prior support of our relationships?
I think there's a targeted effort. And because we're, as Kris has already pointed out, right, like the hanging our hat on marital presumption for shoring up our families and securing our parentage is not going to be sufficient moving forward. Because we're in an unpredictable environment. They've already said they're going to try to escalate to the Supreme Court, a challenge to overturn Obergefell. And if they do that, we still have the Respect for Marriage Act, which would require that marriages that are entered into are respected. And if you can travel to a state where you can get married, then the state that you live in would have to respect that marriage as well. But that would create a lot of chaos and confusion where our families are concerned. And so it's still the best practice to get an order declaring that you're a parent if you're not the biological or genetic parent of a child who you are raising. And so our community is complicated in that way, right? So sometimes somebody gives birth and they're not giving birth to their own genetic child. They're having a shared pregnancy with their spouse. And donor sperm. And so you need an attorney who understands the lay of the land in order to advise you in those kinds of circumstances. Or if you're, part of our community that's even pushing the boundary of family even further, right? And you're looking to have multiple parents, like you really need an attorney to advise you in those circumstances.
Thank you so much, Milan. And Liz Schwartz, an amazing family law attorney in Florida, is sharing that exact same thing to make sure to get court orders. Thank you so much, everyone. We really, really appreciate you. Thank you for joining us. And I want to thank our incredible panelists today for your amazing advocacy and for your bravery. We are in an incredibly difficult moment right now. There's no way around that. But I want to remind you that we've been in this position before where we've had to show that we deserve the same access as everyone else. And in so doing, we've learned how to create a strong foundation and even stronger coalitions and communities that include more of us. We have to remember that the work that we do supports more than just the LGBTQ community. The types of protections that we are fighting for make all of our families safer. And so we know that this work of inclusion is bigger than any one community. It's good for all of us. And so when we are seeing these setbacks, know that we're building something bigger, something better, something stronger. And it will be better than anything that we've had before because there's going to be more of us helping to do it. And that's the work that we're doing. That's the work of civil rights. So many of us have always had to fight for the work, for our rights and protections that, many of our neighbors have been able to just take for granted. But I'm grateful that we are here to do it because this is the only way that it's ever happened anyway, to fight for all of us. I want to remind you, we can't do this work without you. 100% of NCLR's funding comes from people and foundations that simply believe in our work. If you learned something today, or if you understood something in a way that makes it easier for you to explain to someone, please consider making a donation to NCLR or visiting us on our website or any of our social media channels. This makes it easier for us to continue the work we're doing and to host briefings like this so that more folks can know what's happening in our community and what we can do about it. So if you want to find out more information about us, you can at nclrights.org. You can find out more information about our active cases, information facing our communities, about what's facing our communities. You can access our helpline and ask us any specific questions that you might have that we can help you out with. Thank you so much, everyone, and please continue to take care of yourselves and each other. We appreciate you so much.